Right, we'll call the state of Wisconsin versus Connor Gluth. It's 25 CM 1061 appearances. The state appears by Assistant District Attorney Thomas Valerio. I hear in person. Good afternoon.
Attorney Stan Woodard, defender's office, appearing on behalf of Mr. Gluth, who appears by video in the Dane County Jail. I can advise Mr. Gluth that he is eligible for a public defender. He will be appointed an attorney at some point. So we have quite a few requests, but we will get an attorney. I'll represent you for today's purposes, sir. I will acknowledge on your behalf the seat of the complaint. Wait reading the complaint. Upon a finding of probable cause by the court, we stand you as to dinner fee of not guilty.
And Mr. Gluth, give us a thumbs up at the 5523 Prairie Place Drive in McFarland is a good place to get now. If not, a thumbs down in the window.
He appears to be talking, but we can't hear anything over here. Some of the Zoom cards that the bailiffs use has a second mute button on the microphone.
Right, and Mr. Gluth, if you can hear me, give me a thumbs up. All right, you see a thumbs up. So we had an address at 5523 Prairie Place Drive in McFarland. If that's still a good place for mail, give us a thumbs up. If not, a thumbs down. All right, see a thumbs up. I'll make a finding of probable cause and are not guilty pleas to the charges. There is a public safety assessment report that recommends a signature bond. And then I believe we do have a victim on Zoom who wanted to make a statement. If that is the case, you just need to unmute first. All right, I think you're unmuted. And if you can just identify yourself, and then you can let us know what your position is on bail or bond.
Yeah, my name is Olivia Jacobs, and
Just a second. Ms. Jacobs, I think you're here for a different case than we're doing Mr. Gluth right now.
this is the link and time I was given.
Yeah, we have about 20 cases all set for the same time.
All right.
You're here for Angberg, I think. So I think we have somebody else for Mr. Gluth.
Yes, this is Jill Halverson, his mother. And I have a statement, if that's okay to give.
Yep.
Addressing Connor, I had a sad Mother's Day thinking about Connor's behavior Saturday and in the past and his struggles with mental health challenges. Connor's mental state is suffering. He needs to voluntarily seek counseling for his anxiety, paranoia, and anger. Simply put, if he's hurting others, there's a problem that needs to be fixed. Connor has autism, ADHD, and manic moods. He needs to seek short-term treatment, stay at the Dane County Respite Center where he will have a bed, receive counseling for problems such as anger management and mental health issues. If Connor seeks therapy and mental health evaluation, I will reconsider letting him live with me in the future. Connor should work with his father to attain this help, as mentioned, and receive his wallet and phone. Again, if Connor wants help from his family, he needs to go to the short-term respite center for counseling. He has Badger Care insurance. The insurance will pay for it. While this case is open, I agree with the bond requirements, no contact with me, banned from the home, and no possession of dangerous weapons. I really, really hope, because he has potential, to get help for his mental health struggles. Thank you to the court.
Right. And thank you, Ms. Halverson. Just to clarify, if you were banned from your home, is that the 5523 Prairie Place Drive address?
Yes. I'm
And
happy
would
to
he still
receive,
be able to get mail there, with his father acting as an intermediary, or is he gonna need to?
yes,
Okay, so that'll still work for a mailing address.
yes,
Got it. And Halverson, I think, is spelled Halverson. Is that right?
correct.
All right. Thank you for your input. And I'll turn to Attorney Valerio. What's your position on bail?
The state's recommending a $1,000 cash bond. In this case, we're recommending that Mr. Gluth do not use or possess any dangerous weapons and includes any firearms. That the defendant have no contact with Jill H. And that the defendant be banned from the 5500 block of the Prairie Place Drive. Ms. Halverson, is the 5500 block of Prairie Place, is that your residence?
Correct.
Okay, just want to make sure. Thank you. And then I would also ask that the defendant be outfitted or be referred to pretrial services for GPS monitoring to enforce that address ban. So it looks like both counts involved in this case involves the use of a dangerous weapon. That does make them act eligible offenses, Commissioner. And when you look at the facts of the complaint, it's alleged that Mr. Gluth, who we believe has significant health concerns, slashed the tires on his mother's car. And I think what forming the whole basis of this is the fact that be arrested at gunpoint. That's not something that law enforcement does willy-nilly. It's something that they have to do when there's a real risk of harm at play. I think when we were looking at this as well, we noticed that he had a 2017 negligent handling of firearms case where I don't know if you have access to the complaint there, but there it's alleged that he could have seriously injured or killed one of the alleged victims in that aggregate. I will note though that those counts were expunged, but still the fact of that conviction exists. So given the fact that he has this history with firearms, the fact that also appears to get a load of the AR-15 into this room during this incident, I do think that some cash is necessary considering the aggravated nature of the offense to protect the public. The defendant and the alleged victim are clearly know each other. They are in close relation with one another, and I think that cash needs to be applied to ensure their safety. And I think given the nature of this case, I think that I'm on a very condition for appropriate.
Right, and Attorney Woodard.
Two things, Your Honor. First, I'm going to amend my the plea here for not guilty by mental disease or defect, number one. Based upon what I understand, the mother has said, what counsel has said. Number two, I'm recommending an evaluation as to whether or not he can even assist in his own defense based upon his history and the actions that more importantly would have allegedly occurred in regard to this new charge. This young man, from a representation standpoint, constantly needs to understand who he is and what his issues are that cause this to happen. Whether or not those issues would come in because we're not guilty by mental disease or defect, we do not know. But we definitely know at this point whether or not he'd be even suitable to work with an attorney in regards to these charges in light of what we've heard about him. So, with all due respect, Your Honor, that's what I'm requesting for an evaluation of this young man.
Okay, I think the local court rule would ask that I set bail. Do you have a position on the cash bail and the conditions?
Well, we're asking for a modest amount of cash bail, Your Honor. Normally, I would ask for no cash bail. This young man does not have a place to stay in light of this situation. I'm just saying that. That's all. I'm not making a point about it. And as a result, I want to make sure he gets the evaluation. So I'd ask for a modest amount. And if you can't do that, then we'll get somebody here to see him, obviously.
All right, and when you say modest, did you have an amount in mind?
Yes, Your Honor. I would say $350.
All right, and any response from the state? No. And I guess do you want to speak to why $1,000 would be a sufficient amount if it's necessary to protect the public?
Well, I mean, I think $1,000 is enough for someone to reasonably say, if I violate my term of bond by possessing a firearm, which Mr. Gluth has a history of doing at this point, or committing a new crime, which is creating a disturbance in some way, shape, or form that threatens the alleged victim, in this case, their family, then that risk bond forfeiture. We could talk about, what's an appropriate amount. I think that varies. But I think $1,000 is not a reasonable person to say to themselves, well, I don't think that I know I'm expected to comport myself in a community that's a big enough number for me to keep myself from doing that. Now we have to talk about whether or not in Mr. Gluth's case, he's has that mental capacity to even form that ability. I recognize that I agree he has mental health issues, but I don't know whether or not he's legally incompetent such that he cannot stand trial. And I don't know the facets of that mental health problem to figure out whether or not he truly does lack that ability to make that sort of decision making process. All I know is that $1,000 cash is enough for a reasonable person to save themselves. I'm expected to comport myself in the community. That's enough money for me to care about. And so I think that's what we're.
May I speak regarding his psychological?
Go ahead, Ms. Almerson.
So in December, we took Connor to the emergency room after incident, and the emergency room doctor, he was in the protected area, psychological disorders. And at that time, he was working with a lawyer, and he was not able to his mental capacity. He was not able to represent himself or appear in court. He would definitely need to go through evaluation if he's competent to be able to make appear and talk on his own. He has paranoia, hallucinations, talks very difficult to talk rationally in cases, especially when he's having at the manic modes of his life. I guess that's what I'm not very clear, but that's what I would like to state.
All right. Well, Attorney Woodard has raised competency as well as he's entering an NGI plea here. So I appreciate that information. And Attorney Valerio, my last question, is it correct that all of the conduct with the dangerous weapon was directed at the vehicle, not at another person? Am I reading that correctly? Let me just still get my reports.
Yeah, I think that's correct. So the initial call notes indicated that law enforcement was dispatched because I think it was Joel H. was locked out of the house and that the tires were slashed. Reported that her son locked out of the house, stuck like the car tires. The information I don't have indicates that the initial 911 call report saying like the rank was being fielded against Joel H. So I believe you're correct.
All right. Well, I again appreciate the information provided by Ms. Halverson. I think that's certainly helpful in the thought as to whether there's a need for a competency evaluation. I'll find probable cause and find a basis to doubt competency. It is significant to me that the behavior with a weapon was not directed at another human being. It was directed towards the vehicle. I'm not condoning that behavior, and it's certainly scary to Ms. Halverson. But that's significant when we're setting cash bail I have to determine that it's necessary to assure appearance in court. I don't think anybody's making that argument here. And that it's necessary in the totality of the circumstances. These low amounts of bail are, I think, come across more as a tax or a punishment for bad behavior than serving any real purpose to protect the public. He's eligible for a public defender. If I set $1,000 cash bail or even $350 as requested by Attorney Leonard, then maybe he just languishes into jail and is never able to post that. If his family posts it, then I'm not sure it's having the desired effect that the state wants. He's been in jail for 3 or 4 days. If that doesn't suggest that all of this is serious and following the bail conditions is important, I'm not sure $1,000 is the right number. I think it would have to be a much higher number that somebody would have to lose in order to follow the conditions. I think pretrial services is absolutely necessary to protect Ms. Halverson. I hope that Mr. Gluth has been listening as to what she said. Obviously, she's here because she loves you and wants you to get help. And she's, I think, provided a roadmap for that. And you would be able to have contact with your father to assist you with that. But I'm going to order a signature bond with pretrial services on the condition that he only be released between the hours of 8 and 3. I want to make sure that he is on the GPS, a ban from the 5500 block of Prairie Place Drive, no contact, direct or indirect with jail age, and that he not use or possess dangerous weapons as that's defined by the state statutes. I'm also going to order that he just not possess any knives because not all knives are dangerous weapons, depending on what you're doing or intend to do with them. And I think given the circumstances, it's just best that he's not in possession of any knives either, whether it's designed as a weapon or not. Any questions or clarifications from counsel?
No, definitely. Thank you.
All right. And Mr. Gluth, when you get released, and it's maybe not going to be able to be today because of the requirement that it be between 8 and 3, you will need to report to the Dane County Courthouse on the 5th floor to sign up for GPS monitoring. If you don't show up after your release, then they'll notify us promptly, and then there'd be a warrant. And then, as I said, $1,000 I think would be on the light end. If I'm trying to protect the public, it would have to be a much higher amount, maybe one that you're not going to be able to post and you be sitting in jail. Ultimately, I don't want that. I want this to work for you. Pretrial services can also point you in the right direction for mental health treatment if the place that was referenced by your mother isn't something that you're able to get into right away. I do wish the best to Mr. Gluth and hope things improve for Ms. Halverson and appreciate you again taking the time. We are adjourned.
Actually, Molina.
No.
If it's scheduled as a measure and just tenants. Because he put my shares today.
All right, well, call the state of Wisconsin versus Holden, Omar, Molina, 25 CF 1138. We have certified Spanish interpreter and Svensson and all before I forget. Do you swear or affirm that you will truly, accurately, and completely and partially interpret these proceedings?
Yes, I do.
Right. Could we get the other appearances?
State appears by Assistant District Attorney Council area.
Attorney Stan Woodard, Defender's Office for Molina. I can advise Mr. Molina that he is not eligible for public defender. I will represent him for the debate at purpose outside of the possibility. I do have a copy of the complaint. I waive reading of that complaint. as it pertains to felony matters in this complaint. We will be standing mute as the clerk to set a preliminary hearing as to the misdemeanor matters in this complaint. We will also be standing mute and ask the court to plead not.
Right, and you know, is the address on the complaint the best place for mail? Cottage Grove Road. Yes. Okay. And Mr. Molina, the Spanish interpreter, that's going to give you the public defender info. If you're not able to hire an attorney on your own, you can reapply with them, or you can have them point you in the right direction to apply for the county attorney, which would be the middle option. I'll find probable cause for the charges and are not guilty pleas to misdemeanors. There is a public safety assessment report that recommends a signature bond. What's the state's position on bail?
So I have no objection to a signature bond in this case. I would ask the defendant not operating motor vehicle with some they do not use or possess any alcohol. That he be referred to pretrial services or alcohol monitoring. I will note, I think Mr. Molina was just recently convicted of his, at least one of his prior DUIs. And I believe he actually was just sentenced as a WI on May 9th. So I think because he's relatively down in a second world rate with most for defense. Yes, the little now like one tells, and so I think that's why we're asking for the on somehow I start almost even to the same way that very worded. You'll go with me. When you yes, that was the sort of no bullshit on something the sound that lost in every will say it. Yes. If they ever look at and love with that, they don't have anything on with women have battles and manos and You're not getting those necessary recommendations. I think it's reasonable or necessary given the organized conviction and the last 2 years. So I'll order a signature bond, the condition that you're reported to pretrial service. The interpreter's giving you the map to their office. They're on the 5th floor of the Dane courthouse. Right around that corner. The jail. And you would need to be there no later than 10 a.m. tomorrow. In order to sign up, and then they'll equip you with the breathalyzer, the monitor alcohol use, and ordering that you not use or possess any alcohol, and ordering that you not operate motor vehicles at all. Any questions or clarifications about pretrial services, Mr. Molina? We see what you fill up in the train. Your Honor, I have a question. So Mr. Molina understand if he doesn't show by 10 o'clock tomorrow, what if anything will happen?
He's gonna have a body only bench for law enforcement can arrest him and he wouldn't be able to post out bail until he had a hearing rest in the court. And in a lot of those circumstances, this would be rare exception. And then they're setting a cash bail because you have shown that you can comply with the court orders and pretrial service. So super important that you are at pretrial services in the Dane County Courthouse no later than 10 a.m. tomorrow. To this place? fifth floor of the Dane County Courthouse. And where his, actually, I think his other convictions were in Dane County, so I assume he's been to the Dane County Courthouse for those cases. So it's the same place you've been to before. You got to go to the fifth floor by 10 a.m. tomorrow. Check in with the federal services. Your position on the timeline? All right, Mr. Molina, you're gonna go with the valence, you're gonna have to sign some paperwork and give at least yet today, and then make sure you report the pre-trial services by 10 a.m. tomorrow. Okay. That's good. Stuff like that. It's Spanish and everybody's face.
There's be Neil Angberg.
Angberg. Yeah, I'm gonna go back to the corner.
Right. Going the record in the state of Wisconsin versus Neil Angberg, it's 25 CF 1130 appearances.
He appeared by Assistant District Attorney Carissa Ler.
Attorney Stan Woodard with the Public Defender's Office, appearing on behalf of Mr. Angberg, who is a person and who is eligible for a public defender. I do have a copy of the complaint. I waive reading of this complaint, Your Honor, as it pertains to counts 1 and 2, which are misdemeanor matters of final probable cause by the court. You stand you ask the court to enter a pleas of not guilty. Count 3 is a felony matter on the finding of probable cause by the court. We be requesting a preliminary plea.
Do we have the address on the complaint? Or are we using the jail? I think there's a DOC home that's still in place.
Is that is that a correct address? That is correct address, Your Honor.
Thank you. I'll make a finding of probable cause and are not guilty pleas to the misdemeanors. And then I believe we have a victim who wanted to make a statement in the Angberg case. I believe that was Olivia, if I'm recalling. And we would just need you to unmute and just identify yourself and then let us know what your position is on bail and bond conditions.
Yeah, my name is Olivia Jacobs. I'm the partner of Neil. And I am looking to have him out, get him bailed out. Yeah.
All right. And do you have a position as to whether he should be allowed to have contact with you in person or otherwise, or be at your residence?
Yep, I would like contact. I originally never wanted charges pressed on him, and this was told on the initial call. And I would like him to be able to come back to my premise and be able to have communication with me. Am I able to give a statement as well?
Yep, go ahead.
That basically this had stemmed from like a night before previous argument. And we kind of went to bed on like a unresolved note and woke up kind of in the same mood. And he had gone to work and had came back because we just kind of didn't resolve it. And it was over some search that I had looked up on my phone. And basically he had came back to resolve the argument, and I made sure to be clear that I was kind of aggressive towards him verbally. And we argued over the phones and resolved the argument. And I told him to leave so we can take some time apart. And he had somebody to come pick him up. But the person, when they came to come pick him up, had no money or no gas. And so he didn't have a ride out of my place. So I told him to take my car. So that is the reason that he never took it without permission. He never intimidated anybody, not my mom. My mom has no idea, and neither me. And yeah, yeah, I guess that's kind of it.
All right, thank you. We'll turn to the state.
I'm recommending $1,000 cash bond in this case. I'm asking that the defendant be referred to pretrial services for GPS monitoring for the average mass amount of proposed, along with writing drug testing. And then I would also ask that the defendant in contact with Olivia J. That the defendant be banned from the 2800 block of Nicholson Parkway in Pittsburgh. I'm also asking that the defendant not use or possess any controlled substance or drug paraphernalia with that valid prescription. And then I'm also asking that you make findings under that 40.47 based on the information contained in the complaint related to the intimidation of the victim. Based on that 940.47 finding, we're asking that the court order that the defendant not violate sections 940.42, 940.45, and also in order that the defendant not be within 500 feet of the victim at any time. That's pursuant to 940.47 sub 3. So, as you can tell the criminal complaint, right, they are the victim of this created event, and based on his intimidation of her and in his conduct, and in the follow-up text messages, which tell her not to report to police, she refused initially to identify the defendant at all, and even refused to have injury photos taken. Eventually, she made clear that the defendant did this to her, that she had physical injuries, including a crooked nose, bleeding and bruising on her arms, as the injuries involved here. This is an agri-eligible case. Under the totality of the circumstances, cash feels necessary to keep the victim safe. This defendant is flight risk. He took active steps to evade detection from law enforcement after assaulting the victim. And then he also had 22 grams of marijuana on this person when he was arrested against the drugs condition. Furthermore, I'll also note, as the court referenced already, there is DOC hold on Mr. Angberg as he does resign community supervision when he commits this offense. He was convicted of two counts of misdemeanor theft and 2 misdemeanor level financial fraud or financial transaction card fraud cases in Dodge County case number 24 CM 31. And then he was convicted of fleeing and eluding officer in Manitowoc County case number 24 CM 357. And for all of that conduct, he was sentenced to 3 years of paper. So he's allegedly committing these offenses while he's on the term of supervision. He's intimidating the victim through various acts, which in and of themselves show express acts of subterfuge, which he's going to bring forth in order to obfuscate what happened. All that's incredibly concerning from that perspective. And then you add on top of the fact that these are all that this is an agri-eligible case. I think that some cash is necessary.
Right. And is there a prior violent history? If we're talking about Act 3, obviously I don't have the benefit of PSA since he's on a GOC hold. They don't do those in most cases. And while you're looking at that, we can hear from Attorney Weber you can speak of Mr. Angberg. State wording.
Am I also able to add more to my statement as well?
Briefly.
There have been false accusations. I have confronted the officer who originally is saying these text messages of intimidation. The 2 text messages specifically are do not let the cops or do not tell the cops that I broke your nose. Because he didn't. It is on every single body cam footage that I have fallen into the closet. It is evidence on the closet. I was the one who had pushed him. He moved away and that made me fall and I had stumbled on the closet. The intimidation for my mom was he texted me telling me, do not let your mom go in the basement to see that the car is gone, because that is technically my mother's car. And so he did not want her to know that he had the car. And so they took that as intimidation. So that's where that is coming from. And that is completely false.
All right, thank you.
I will note that the only violent history involves Mr. Angberg's juvenile history, so it looks like he was convicted. Well, there's an adjudication of delinquency in 2019 for burglary of the building or dwelling and that seafood boiler. And then I think there was. I think that's the only like Act-3 eligible conduct that he's engaged in crimes religiously.
All right, thank you. And Attorney Waters?
Yes, Your Honor, thank you. Mr. Angberg, is that the same frame of mind as the alleged victim? By that is staying away. Doesn't want to talk to her, there, follow through with doing what he needs to do, but he has no problem with staying away from her. As there may be some assumption that you may try. No, at least in talking to him, that's not going to happen. It also is a situation here for pretrial services, and I understand we got a request by the state. Am I correct on that?
Yes.
Yes. So with pretrial services, it means
Well, before you spend too much time talking about that, I guess I'm generally disinclined to order pretrial services when somebody's on supervision. I think he's on supervision for a couple of felony for property offenses. Is that right?
For one felony failure and then 3 misdemeanor theft related. Yes.
No, he's either going to get removed, he's going to be in custody, or he doesn't need to be monitored, or he's out and they should be monitoring him. And they have the capability to do GPS and random UAs and all of that. I just don't want to duplicate these sources.
I understand you, John. We were requesting $500 cash fee. All right.
Well, I'm concerned about whether Mr. Angberg's going to show up in court. I got somebody who has a fairly recent clean conviction. That charge to me is consistent with somebody who's shown that they're just not willing to show up in court because they endanger themselves when they engage in that behavior. He's then on supervision for multiple charges and picks up a violent charge and a felony charge. And since supervision wasn't successful, there's certainly a lot more likelihood of prison. Whether cash bail in the amount of $1,000 is necessary to protect the public, I'm not so sure that that's the number that does the trick. He's either getting revoked and is going to be in custody, and the public at that point is very protected, or he will be on supervision and they can have all of the monitoring that pretrial services could. I'm going to set $500 cash bail to assure his appearance in court. I'm not going to order pretrial services. I'll order that he not use or possess any drug paraphernalia or controlled substances unless he has a valid prescription. He's saying he's not going to have any contact with the victim. I think given the intimidation and what I read in the complaint, that's the best course of action for everybody right now. And we'll order the no contact director with Olivia J and a band from the 2800 block of Nicholson Parkway in Pittsburgh. I will make a finding pursuant to section 94047 based upon the alleged intimidation in the complaint, that there is a reason to believe that knowing or malicious prevention or dissuasion is likely to occur. And in order that no contact and ban pursuant to section 94047. I'm not ordering the GPS or random UAs. That's something that his agent certainly can do. What's his position as to time limits on a preliminary hearing?
Go away, Your Honor.
Okay, now you're adjourned.
Actually, before we do that, what was the ruling on the not using the fee of the looking at Jane?
I will order that. I guess I thought that was just a restatement of the statutory intimidation, in which case it wasn't necessary, but if that was to be a extra condition, it's reasonable and I'll order it. Okay, thank you. You're welcome. Okay, I think you wait time on it, so we are adjourned. And thank you, Olivia.
Red Stones, they're going to get attorney tomorrow.
It's absolutely.
Yes, that's true. Substantial amounts.
Deputy Richard Fenny.
Penny. Stand on the yellow, starting with the
Go on the record in the state of Wisconsin versus Richard Benny Jr. is 25 CM 1060 appearances.
State approved by Assistant District Attorney Thomas Valerian.
Attorney Stan Woodard with the public defender's office, appearing on behalf of Mr. Betty. Say that right, sir?
Yes, you did.
Okay, who represents the person counsel. I can advise the court he's eligible for a public defender, so you can get an attorney from one office. I do have a copy of the complaint. I'll wait reading of that complaint, Your Honor. There's two counts that are misdemeanor with that. But my problem was talking about in court and Stan, you that's for there, please, I'm not guilty.
And do we have a good address for Mr. Penny on the complaint?
3598 Steuart Wood.
That's what we have. Thank you. All right, I'll make findings of probable cause. We'll get not guilty pleas added for the charges. There's a public safety assessment that recommends a signature bond. Well, I believe we also have a victim on this case. I think they see them on Zoom. If you could just unmute and then identify yourself first, and then let us know what your position is on appropriate bail and bond conditions.
Helena Lee. I don't want no contact with Richard. I fear for my safety and my son's safety. I would like them to go through drug testing and mental health services.
Okay, and Helena looks like it's spelled Helena.
Yes,
All right, and is Lee Lee?
common spelling, yes.
Okay, very good. Anything else you want to say, Ms. Lee?
No, thank you.
All right, thank you. And Attorney Blair, what's the state's position on bail?
I have no objection to the signature bond in this case. I would ask the defendant to have contact with Helena L. That the defendant began from any place Helena L resides or occupies. And that the defendant not use or possess any controlled substance or drug paraphernalia without valid prescription, and that do not use or possess any alcohol.
All right, and Attorney Woodard, any objections?
Good for that. We have no contact with all of it, but I'll see how the drugs where the alcohol is. Counsel for the state, is there indication of alcohol? I didn't we're indicating that alcohol wasn't a major factor in regards to the charge.
Well, I'll know that Mr. Penny admitted to drinking and using marijuana.
I did,
Sir, don't interrupt. You may not want to say anything because you have the absolute right to remain silent. This is all being recorded, and anything you say can be used against you later on. So go ahead, Attorney Valeria.
He, like I mentioned, he admitted to drinking and using marijuana. And I think when we look at the violent nature of this offense, at least part of that could be attributed to the usage of the alcohol or drug scene in the state gang. I think that's a fair request to ensure the state.
Right. And then any response from anyone?
we know the marijuana is illegal, Your Honor, so we're not requesting that, obviously. But the alcohol situation, I think us to maintain their opportunity to be able to handle alcohol the next after. We wanted to do that, it's from our standpoint, is requesting that you allow to drink alcohol with in a respectful way.
Well, I guess the only disputed issue is the alcohol issue. If I had a nickel for every time victim said that somebody's a wonderful person, except when they're drinking, I'd be a rich man. And I'd also be a rich man if I had a nickel every time somebody at sentencing and gets convicted of a violent offense says the alcohol is what led to the violence and the bad decisions. So when I see violent charges and alcohol involved, there's a pretty good reason to think that that may have played a role, and perhaps a significant role. So I am gonna adopt that as a condition of his signature bond along with the no contact direct with Helena L and any place that she resides or is temporarily occupying. And I'll order that he not use or possess controlled substances, drug paraphernalia without a valid prescription. It's maybe redundant because it's already the law. But it reminds you marijuana is not legal in the state of Wisconsin. You can't use that either or any other illicit controlled substances. I understood the request for drug testing. It's not something I would be ordering at this particular point in time. I hope that these conditions are followed. If not, then pretrial services, then that active supervision and monitoring is maybe necessary, or perhaps cash bail if you're not following the bond conditions. All right. We will be adjourned. And thank you, Ms. Lee, for your input.
Well,
Really says there. That would be Michelle and Manny.
Thank you.
So we not the housing. Yeah. Then here's the season everything else.
We'll go on the record in the state of Wisconsin versus Sean Manny or Manny. 25 CM 975 parents.
He's here's by Assistant District Attorney Thomas Valerio.
Is it Manny or Manny? Manny. Okay, thanks.
Attorney Shannon Waters was the public defender's office, appearing on behalf of Mr. Manny, who appears in person and who is eligible for a public defender. And you have a copy of the complaint. I'm waiting reading that complaint. The 2 counts contained therein that are misdemeanor matters. But finding problem by the court to stand mute, that's virtual plea to not guilty.
Then we have good address on my complaint.
Circle for son. Yeah, that measure. He does have an address, Your Honor. Not here in Madison. You gonna do him?
Yes, it's Lexington, South Carolina. I've been there for February 19th.
Okay, but what's the street number and street name?
It's in my paperwork. I actually stay with my brothers where you mail the information to Father John.
Well, it's got many cases, so maybe it's been updated in those, do you think? And 25 CM 551 looks like we have 270 Greenview Court, Lexington, South Carolina, 29072. Is that correct? All right. In regards to this case, I'll make findings of probable cause. We don't have a PSA for their standalone bail jumps. I was told this one might have a victim. I guess I don't see anybody on Zoom. It's now 20 after 2. I think we've waited long enough. We're able to proceed, Attorney Blair.
Yes, we can proceed.
All right, you can make your argument on bail.
I'm recommending a $500 cash bond in this case, along with the condition that the defendant have no contact with me for that. For the record, that's spelled ANTIONETTE. This is pretty straightforward, Commissioner. It looks like it's alleged that Mr. Manny contacted Antoinette after being ordered not to do so by additions of the spot. It looks like he currently has, besides this case, 2 open domestic related instances involving Antoinette and the alleged victim. In both matters, he's ordered to have no contact with that individual, and regardless, as is alleged in the criminal complaint, and Mr. Manny sent their landlord an email, CC the victim, making various inflammatory allegations and statements against the victim. This occurred 3 weeks after Mr. Manny was so ordered, in both open cases had no contact with that victim. He already had $150 posted in one of his open cases, so I think more cash is appropriate.
Well, just to clarify that last point, maybe the clerk knows, I think he had posted 150 pursuant to the bond schedule. to be released, and then got his signature bond. So I'm not
Yes.
sure he's out on 150 any longer.
Yeah, let me, that you are correct. So it looks like that cash bond was posted, I believe it was in February 14th of this year. And then that was changed to a signature bond on March 30th, 2025.
All right, thank you. Also looks like there might be a temporary restraining order filed by the victim in Dane County case 25 CV 1591. Attorney Woodard, what's your position on Dale?
Your Honor, Mr. Manny, as we know, is eligible for a public defender. I say that again because of his the wherewithal for him to post cash bail. And at this point, where he did post a modest amount of cash bail, at this point, he does not have access to additional cash bail. On his behalf, I'm going to go ahead and recommend signature bonds. But in the alternative, I will be asking for $350 of bail, Your Honor. The event in court does not see fit for another signature.
I'll agree with Briefing.
All right, well, I don't think there's any question that cash bail is necessary when you've got a couple other cases. You're not supposed to have contact with this person. Then allegedly you have, allegedly there's a temporary restraining order also out. So I'll set $350 cash bail order, no contact, direct or indirect with Antoinette M. And we will be adjourned.
Great, so that's certain. Next week, Bruce Newbower via Zoom.
All right, we'll call the state of Wisconsin versus Bruce Newbower, 25 CF 1134.
The state appears by Assistant District Attorney Thomas Valerio. I personally.
Attorney Stan Woodard with the Public Defender's Office appearing on behalf of Mr. Newbower, who, as I understand it, does not want a public defender. At least that's what the form says that I have, sir. If you wish to have a public defender, I can represent you for today only. Or if you wish to represent yourself, or if you want to get an attorney, it's your call. How you want to proceed, sir.
All right, and so Mr. Newbower, give us a thumbs up if you'd like Attorney Woodard, who's an experienced attorney, to assist you today. All right, it looks like he's pounding on the doors.
I guess I'll note again that based on the pounding, it doesn't seem that the microphone is working.
Yeah. And perhaps the bailiff can unmute. Mr. Newbower, can you hear us?
Yeah. Thumbs up. Thumbs up.
All right. And so you would like Attorney Woodard to assist you here today, as opposed to representing yourself or adjourning the matter. So you have an attorney. The downside of adjourning means you're going to still be in custody and not have any bail set. So do you want Attorney Woodard to assist you today?
I need to ask questions. That is one thing I know.
Okay. Well, maybe we might want to pass this one for a moment, and I don't know if Attorney Woodard is able to go down and speak with them. There's also some concerning statements in the complaint in regards to the mental health issues. Yeah. But, all right, we're back on the record in the Bruce Newbower case. Appearances are before Attorney Woodard. You've had a chance to speak with Mr. Newbower.
Yes, I did, Your Honor. Mr. Newbower, he's got some mental health issues. So he blew up on me, not personally, but he blew up on me I began to try to talk to him about what we can do and seek bail for me.
I think given that and some of the things I read in the complaint, I wouldn't be comfortable allowing him to represent himself here today. And also don't think it would be a good idea for him to delay the proceedings to get another attorney. He's certainly free to get a different attorney. He doesn't want a public defender after today, but I guess we should.
I can proceed. You know, I'm going to ask that he get an evaluation, man. You know, but that's from him. And then just be aware, Leonard Taylor will be coming up shortly, and he was across the hall, if you will, and.
Well, we can talk about that case when we
those who were joined at the hip. Let me just put it like that.
Okay.
See
Well, so let's
go on the record.
go on the record. You have a copy of the complaint, correct?
Yes, I do, Your Honor.
All right. And waiving a formal reading.
Thank you very much. I'll wait for reading that complaint. I have reviewed this complaint as a serious matter, a felony matter for finding the probable cause by the court to be requesting a preliminary hearing, but first before that, I'm going to be requesting an evaluation in regards to his mental health.
All right. And let's make sure Mr. Newbower gets the public defender information. Since he wasn't eligible, he's certainly free to hire an attorney after today. But if you can't hire an attorney, you can reapply with the public defender or apply for a county attorney, which is the middle option. I don't know if you had different mailing information than what's on the complaint for Mr. Newbower.
I wasn't able to get that at all, Your Honor.
I didn't know if when they talked to him, they got that, or if somebody just says they don't want a PD, then they stop the discussion.
I have no idea. Other than what we have on the complaint.
Okay, I'll make a finding of probable cause. What's the state's position on bail? Even though competency's been raised, I think the whole court requires us to address the bail.
I'm asking that the defendant, or excuse me, I'm requesting a $5,000 cash bond in this case. I'm asking that the defendant not operate a motor vehicle, that he not use or possess any alcohol, that he not use or possess any controlled substance or drug paraphernalia without a valid prescription, that he have no contact with John M. or Robert S. The record, John's first name is spelled Jon as in Nancy. So first I want to get out of the way the fact that throughout the court proceedings and through the request for competency evaluation, there's more than likely mental health component at play here. I think that's further evidenced by the fact that Mr. Newbower has no criminal history whatsoever. So he's got, my understanding is that he has connections to the state of Illinois, whether that's the prior addresses there from our NCIC logo of them. And even there he has no criminal history, and he's a 25-year-old man. On a case like this, where it's alleged that, officers were called out to the scene downtown because the suspect vehicle hit two people, launching one of them 20 feet in the air and injured that individual, you're probably looking at the case for the state would be asking for far more cash bond than just $5,000. I think we're taking into consideration the fact that Mr. Newbower is young, he has no prior criminal history, but we're balancing with the fact that this is a really serious case. As I mentioned, the facts of this case are incredibly egregious. Although the victim has reported back to our office that they have compression fractures to two vertebrae in their lower back. And he confesses to law enforcement he was looking for a specific person to mow down this vehicle that says he hit the wrong person / people. It also is concerning that he does have those connections out of state for this incredibly egregious offense. So I think when we balance all that, I do think it's a significant amount of cash. I think $5,000 is appropriate amount.
All right, Attorney Ward.
Your Honor, in light of the situation, talk to him or try to. I'm going to ask for a signature bond. I realize that's a lot in light of the situation. I don't think he has any wherewithal for the cash bail. So I'm just going to ask for a signature bond.
Any response, Attorney Valerian?
I don't think it should be a signature bond. I think we're looking at an accurate eligible offense for someone very well qualified. And I understand there's plenty of health issues at play that's not confirmed yet. I think in the meantime, I think the public needs to be protected and paying $5,000 suitable for that.
All right. Well, I think there'd be a very good argument for cash bail just on the risk not to appear. He has apparently no ties to the state of Wisconsin. He's looking at a very serious felony charge that could end up in prison, and that provides incentive not to appear in court. I have grave concerns about public safety with this particular case. The criminal complaint suggested that it may have been a mental health issue, maybe some paranoia that people were following him. Correct me if I'm wrong. I think the complaint suggests he was essentially driving on the grass and then sidewalk. These people were not in a crosswalk when they got struck. It's extraordinarily dangerous behavior. I'm sympathetic to people who have mental health issues. But this is a situation where I set a bail, but he just goes out onto the street and doesn't have any mental health treatment, and he wouldn't be required to just because we're raising competency here. I have very serious concerns that he would go out looking for this person who probably doesn't exist, trying to run them over. I think I need to make sure the public is protected. You know, it'd be a different story if somebody said, all right, we actually have a bed, he's going in patient, and here's how we're going to get him there. We don't have that. I'm going to set $50,000 cash bail. I'm going to order that he not operate a motor vehicle at all, that he not possess or consume any alcohol at all, that he have no contact, direct or indirect with John N. and Robert S. Given the mental health issues, I just question and the competency which has been raised that he would be able to follow any of these conditions and protect the public. So while it is a significant amount of cash bail, I believe it to be firmly necessary in this case. I'll find a basis to doubt competency based upon kind of his demeanor and banging on the walls. He's in segregation. The statements that I kind of already addressed in the complaint, and Attorney Woodard having an opportunity to speak with him. He's an experienced attorney and believes there's a reason to doubt competency. So we'll pause the proceedings to get an evaluation, and we'll be adjourned.
That's what he's Steuart, Wescott.
Great. We'll go on the record in the state of Wisconsin versus Steuart Wescott. It's 25 to CM 1056 appearances.
State appears by Assistant District Attorney Thomas Valeri.
Attorney Stan Woodard with the defender's office here on behalf of Mr. Wescott, who appears in person and is eligible for a public defender. You have a copy of the complaint. There are two counts contained in this complaint. They are misdemeanors. But findings probable cause by the court, the Sam Youth, Escort General Police of not guilty.
Right. And are we using the beacon for a mail for Mr. Wescott?
Yeah.
Okay. And we'll make a finding of probable cause for the charges here. I don't see a public safety assessment. What's the state's position on bail?
I have no objection to the signature bond. I would ask that the defendant began from the UW campus as that's indicated in the band map that we have. And then I would ask that the defendant have no contact with harm. Their first name is spelled AHAAN as an answer.
Any objections?
Yeah, I just found a backpack playing.
Okay, well, I don't want you to say anything, Mr. Wescott, because you do have the right to remain silent, and this is all being recorded. And
I don't mind.
You can be used against you later on.
Watching, right? It's like you believe in God. I believe in God. So God would have no problem if he tell you that. I just found a backpack laying in the middle of the parking lot. And then was going to hand it back into the school. It was a Sunday. The school wasn't open. So I waited till Monday to buy the rest of Sunday night. I don't know how it tried to do
that. And that may be, but today's not a trial, as you're probably aware. Today is just the initial appearance.
Today.
Okay. Well, I'm gonna order a signature bond. I'll order a ban from the UW campus. So order no contact director of the Han B. The deputy's giving you the band map. It's everything inside that dark outline. Anybody have any concerns about competency?
Not at this time, Your Honor.
Yeah, I don't have anything.
Okay, we are adjourned.
Pleasure. Step over the morning.
Close.
Close. Yeah. Okay. That could be Carissa Ler. Here's Sam.
Right. We'll go on the record and say Wescott versus Carissa Ler. It's 25 CM 1063 appearances.
State appears by Assistant District Attorney Thomas Valerio.
Attorney Stan Woodard before the defender's office, here on behalf of Mr. who appeared in person and is eligible for calling the defendant. We have a copy of the complaint, wait reading that complaint. So one count misdemeanor matter, finding probable cause by the court, we stand mute. Ask the court to plea and not guilty.
And we're using the address on the complaint.
That is correct, Your Honor.
Okay. Make a finding of probable cause if the POC hold has been dropped. And then there's a public safety assessment recommends moderate cash bail. What's the state's position?
I actually have no objection to the signature bond in this case. I would ask the defendant and use or possess any identification cards or financial instruments that are not.
No objection to the recommendation made by the state, Your Honor.
Okay, we'll order a signature bond. Those conditions will be able to not use or possess any identifying documents or cards or any financial cards or documents. And we'll just state that that's unless they are lawfully in your own name. And then that's going to take care of it for today. And I think the hold of drops. I think you're getting all those things. All right, we are adjourned.
Good, so yeah. Thanks to Leonard Taylor via Zoom. Because they made some of this. No, okay.
All right, we'll go on the record in the state of Wisconsin versus Leonard Taylor Jr. That's 25 CM 1055 appearances.
The state appears by Assistant District Attorney Thomas Valerio back here in person.
Mr. Taylor appears by video from the Dane County Jail with Attorney Stan Woodard from the Public Defender's Office. I indicate here that Mr. Taylor has said he does not want a public defender. I can ask you, Mr. Taylor, would you want me to represent you for today's purposes only? Or do you wish to go another way?
I guess I've got concerns about that. I think they've had cases with Mr. Taylor had competency rate.
Oh, I see. Okay.
So if you're willing to assist today,
I'm happy to be your honor. It's not a question. I'm just listening. It's fine.
And Commissioner, it sounded like maybe there was some noise or words that were partially coming through the Zoom connection, but I couldn't hear what they were.
Right. And I couldn't hear him either. And I just took a look to make sure my recollection was correct. I think I'm recalling some older cases, but the more recent one, he's had a competency raised. And I hear noise in the background, but I'm not sure that was Mr. Taylor. But in light of those concerns, I think he needs an attorney to assist him here today if you do that. Attorney Woodard. Did you waive the reading on that?
Sure. Excuse me, Your Honor. I can advise the court to have a copy of the complaint. I waive reading of that complaint, Your Honor. There appears to be two counts of a misdemeanor matter from finding the proper cause. We would stand mute. That's the question. I plead with not guilty.
All right.
I think in light of the history here regarding his ability to understand things or thought that whether or not he is competent to proceed, I have questions about that, Your Honor. So I'm going to be requesting a competency evaluation on this new charge. On these new charges, excuse me. And I would be recommending a reasonable amount of cash bail. That would be $300.
Any response from the state?
He said bring it around.
Yes, it is.
I'll agree with that.
I think that's pretty reasonable in light of the nature of the charges here and the incentive not to appear. I think cash is probably warranted given he's picked up bail jump and then he's not compliant with the competency evaluation. I'll set $300 cash bail, order a ban from the UW campus per the ban map. Find a basis to doubt competency. I think they already found probable cause, but I'll reaffirm that. And we'll suspend the proceedings so he can be evaluated. We are adjourned.
Next me, Percy Hansen. And.
On the record in the state of Wisconsin versus Carissa Hansen, 24 CF 1451 and 24 CF 1910. These are all return on warrants appearances.
The state appears by Assistant District Attorney Thomas Valerian.
Attorney Stan Woodard with the Public Defender's Office, screen on behalf of Ms. Hansen, who is appearance in person. And I must advise her that at this time she is not eligible for a public defender according to the evaluation done by our office. I can advise her though that she can always follow up again and talk to our office about that. And there may be a change in regards to the not eligible at this point. That does happen from time to time.
All right, and she's been given the public defender information, so she has that. Can we confirm that we still have a good mailing address?
Speaking of mailing address, on CCAB shows my mailing address is the Dane County Jail, which I have no idea why I changed, and that's why I did not get the notice of hearing. That's why I missed this last court date. So yeah, no notice.
I see 1306 Nevada Road, Madison is the mailing address on CCAP. Is that the correct address?
My CCAB shows was South Doty Street. I was here on April 29th and I court May 2nd. They didn't tell me anything about it.
Okay. So we got the correct address, so.
Yeah.
All right, any additional information you want to provide about the missed court date, Attorney Woodard?
Yeah, I got a notice in the mail and anything, they didn't tell me on the 29th of April when I was here that I had court, so it's initially why I missed it, but I'll go ahead and.
You mailed her, Your Honor, which is fine. Ms. Hansen is indicating that she never got any notice for the day. For the dates, for the court date that has been missed. And then I'm sorry.
I also called up there Friday, and he told me that I paid $2,080 for missing court or I consider the weekend.
Okay. Attorney Valerian, what's your position on bail?
Sorry. I think my understanding, correctly if I'm wrong, is that in the 24 CF 1451 case, she's on a $100 cash bond, is that right? Yes, that was posted on August 15th of 2024. And then I think in her 24 CF 1910 case, she has a $100 cash bond. Is that the thing?
No. Sounds correct. Yeah, $100.
Well, I'm asking that you convert those to each to $500 cash bonds, and I asked you that they forfeited, so the $200 currently goes to the body. I mean, bottom line here is the fact that Ms. Hansen has bench warrants issued on August 9, 2024, April 22nd, 2025, and May 2nd, 2025. She's on bond for 2 felony level offenses, and I'll note that in the Brady's matters, right, it's been made clear that she needs to appear before it and she needs to take steps to ensure that she comes to court. I think, we have now 3 missed court appearances in a relatively a short period of time. I think we have to stand so that she can't do this anymore. And I think that comes to the point where I think greasing cash. And I think given the gravity of these offenses, 500 on each victim is reasonable.
I can try, it's just like, doesn't have the amount to know about, and for it, really did not be my fault, as I'm saying. Like. I could try, you know. You know, so, I think we'll see. But I didn't come.
Well, Ms. Hansen, does have some, does understand that this is a situation where some extra bill is going to be recommended and probably followed by the court, I'm sure. We're looking at the extra $300 for each case here.
All right, and the clerk popped me out. He thought that Ms. Hansen was maybe referring to a couple of other cases. I poked around with that. I think in 25 CF 920, there it says Sheriff Dane County Jail. That's a case where she got $800 cash bail on April 29th. And so I think you're referring to a couple of your more recent cases. These are the older cases.
No, I know this for next year, my first ones.
And we had the correct address when notices were sent in those. Any response, Attorney Valerio?
I think the cash fund now proposed by defense counsels. I understand. There's no problem. I just don't agree with that amount. I mean, it looks like throughout the life of Ms. Hansen's cases, we've been trying this really incremental step up in cash bonds by just ordering $200 cash. And Ms. Hansen still isn't getting the picture. She needs to show up to court. So we need to do something different, right? And I'm not asking for a huge amount. I recognize it's a huge amount, I'm sure, to Ms. Hansen, but in the grand scheme of things, it's not a completely unreasonable amount. And I think it's needed at this point for Ms. Hansen to understand she needs to show up for.
All right, and it looks to me like she just posted $1,200 in those newer cases. Does that those sound right?
Sure. Did you see that in 25 CF 634, $400 was posted to the sheriff's office on May 1st of 2025. It looks like that amount was previously forfeited, and it was then reinstated on April 28th of 2025. So she was able to still post that on the reinstatement. And then it looks like in that same case, I see $400 posted with the sheriff's office on May 12th, 2025. And then I think we have a $100 posted that I just mentioned. Those are for Dane County, though. And do you see that's too old for us to or no? I was looking at a Columbia County case, but that's from 2007. That's real. But it looks like she's had the success posting those $400 amounts, then the $100 must be already.
All right. There's a need for cash bail. You've got multiple cases. There's this court. You've posted cash bail. I'm gonna set $750 in 24 CF 1910, and I'll set $500 in 24 CF 1451. I think that latter cases they serious, and then we'll keep all the prior non-monetary conditions and send these back to. Well, actually, it says to be reassigned, so it's going to be branch 12 now. Is that correct?
These are going to branch 12. That's Judge Peacock. The other two cases, because they haven't been bound over yet, will not be scheduled at the same time. I believe those are set for May 21st.
For 24 CF 1910, Your Honor, what was the amount to?
$750.
$750. Thank you.
Okay, we are adjourned. All right, make this item.
I thought it was gonna be Javar.
That already happened. Sure. Like the initial power button. And then these are
The number again. Did you hear the?
Oh, Jasmine H. Hanger.
Got it.
You're missing Hanger, right? Well, call the state of Wisconsin versus Jasmine H. Hanger, 25 CF 1132. Appearance.
The state appears by Assistant District Attorney Thomas Valeria.
Attorney Stan Woodard with the front of the business office for on behalf of Miss Hanger, who appears in person and is eligible for a public defender. I do have a copy of the complaint. I'm waiting reading of that complaint as it pertains to count 2, which is a misdemeanor matter. By finding the probable cause by the courts, we stand view. That's correct. Pleaded not guilty. Count 1 is a felony matter. On finding the probable cause by the court, you be requesting a preliminary hearing.
And we have a good address on the complaint.
That is the correct address on the complaint, Your Honor.
Okay, I'll make findings of probable cause. We'll get a not guilty plea to the misdemeanor. State's position on bail.
So I'm asking for $1,000 cash in this case for conditions. I'm asking that Miss Hanger not operating motor vehicle and that she not use or possess any controlled substance for drug paraphernalia without a valid prescription. First, I want to preface this by saying this Miss Hanger has any criminal convictions, right? So there's nothing I can say, Miss Hanger. I can't say that Miss Hanger's been to appear for court. She does have county infractions, but they're not criminal convictions. Still, we are looking at a pretty bad claim when we look at the grand scheme of events. Here, it looks like Miss Hanger, police from not 1, but 2 different law enforcement agencies at a really high rate of speed. I believe we made it into the complaint that should allege that law enforcement pursued a speed of up to 123 miles per hour, which is way too fast. It's alleged that Miss Hanger violated traffic signals, then they in her vehicle to flee on foot. And if that's not bad enough, the Fitchburg Police Department made contact, or excuse me, the law enforcement agency had to release a canine unit to pursue Miss Hanger and bring her down. And one of the reasons we can infer a reason why she fled is because there was cocaine found in her purse in a vehicle she was driving. In fact, my understanding is that she had to go to the hospital to be assessed for a dynamite that had to be inflicted upon her in order to get her to stop. So look, this is a pretty aggravated claim in my eyes. Miss Hanger has no criminal history. I think that fairly, I think the court should fairly consider that. But when I weigh it against the really high aggravated nature of the claim older thing, I think that a substantial amount of cash is needed.
And Attorney Woodard. Thank you, Judge. One moment. Miss Hanger realizes the allegations contained herein, but the wherewithal cash is limited, but she can't for $500.
Any response from the state?
Did you recommend money in your own?
No.
Oh, no. Look, I get it, right? I get that Miss Hanger has no criminal history, but I'm sorry, when you're playing law enforcement in such a way that you are going 3 digits, over 120 miles per hour to escape enforcement, violating various traffic offenses, getting a canine unit to bring you down. It's all very concerning behavior from the Carissa history perspective, and I think that's the same for casualty. Yes.
Sorry, Attorney Winter, you can have the last word when you're done speaking with Ms. Hanger.
Well, Ms. Hanger does have some issues about the speed, but we're not gonna bring that to the court. We realize what the church and so on. But I think. Right. Yeah. 500 is the best you can do, Your Honor. Your first time around, we think that's a reasonable request. We're not appreciating what the charges are. But in light of this situation, the first time around, we'll type of this is. We got much about it.
Well, I think law enforcement told Ms. Hanger in the complaint that she sounded she wasn't going to be going to jail for the cocaine charge. I would echo that. She got herself in a whole lot of trouble by not stopping, fleeing law enforcement. I understand these are allegations at really high speeds, you know, whether it was 90 or 123 in the areas that she was traveling on highly trafficked areas at about any hour of the day. And when people do that, they're telling me I ought to be concerned about whether they're going to show up in court without cash bail. Because people flee because they're afraid to get in trouble. Now you're actually in worse trouble than they thought you were when they fled from law enforcement. And it's a pretty aggravated eluding, given the speeds and just the duration of it in multiple agencies, and then not compliant after the actual driving behavior. I'm not going to set a less than $1,000 requested. I'll order that, and I'll order that you not operate a motor vehicle and that you not use or possess any controlled substances for drug trafficking without a doubt prescription. What we can do is get it set for a preliminary hearing in the next 10 days. Should we do that? Is that Attorney Wood?
Yeah, sure.
Okay. We are adjourned.
Next is Jasmine Meltchure.
Go on the record in the state of Wisconsin versus Jasmine Meltchure. It's 25 CF 1133 appearances. Here's my assistant district attorney, Thomas Doyle.
Attorney Steuart was going to put up we asked Ms. Meltchure, who appears in person and is eligible for public defense. I have a copy of the complaint. I will read that complaint, Your Honor, as it pertains to misdemeanor matters contained as can on public dog driving court. We say on mute test pertinent pleas are not guilty. Now, one is found in the matter about Friday probably found by the court. We be requesting a preliminary hearing and her address. The address on the complaint is correct, Your Honor.
Make findings of probable cause and are not guilty pleas for the misdemeanors. State's position on bail. One second, I just want to double check one thing here. Commissioner, you don't see her on a DOC board, right? I didn't see that on my sheet unless the clerk saw something. Oh, right. That sounds right. I think I just wanted to double check and make sure. Okay. All right. So the state is recommending a $2,500 cash bond in this case. I'm asking that the defendant not use or possess any alcohol
then she'd be referred to pretrial services for alcohol monitoring, and then she had no contact with the child victim one or the director for both this here. 1 second. Child victim one's initials for the bottom form are going to be M-E. All right. So here's what's going on. This Meltchure was convicted, I believe, in 2021 of child abuse. Physical abuse of a child recklessly causing bodily harm. With an incident the date of 2020, it looks like she was placed on 2 years in probation, and it looks like that lapsed, right? So I don't see that this event occurred while she was on probation. Still, it's concerning to me that it happened really close to her terminal probation. And furthermore, I know that bench warrants were issued against this Meltchure on August 13th of 2024 and then December 17th of 2024. And what's also really concerning is that that December bench warrant was not served on her until April 11th of this year. She was in warrant status for like a good 4 months.
Your Honor, Ms. Meltchure is requesting that she get a signature bond with pretrial services that could watch her in terms of where she goes, whenever she can wear. They have there around the ankle and things like that, so they know where she's going. And this is none of the same. We're on the alternative is $500. I mean, my recommendation. But at this point, she doesn't think there's any income at this point is going to be too much for her. But she's willing to go to pretrial service.
Well, the felony charge for the reckless child abuse and the repeater is more serious by virtue of the charge that is the basis of that repeater having been convicted of the exact same conduct and supervision been found. And so what that means to me is it's much more likely that if convicted, you might get a prison sentence or certainly confinement or jail time as opposed to just supervision because there's a history. You were also out on bond. That's concerning from a parent's perspective. The obstructing somewhat concerning, although it's not the most egregious obstructing that I've seen. Well, then we've also got, I believe, 2 failures to appear relatively recently. I think there's a need for cash bail. I think a lesser amount can get Ms. Meltchure to appear in court. My number is $1,500. I don't know, or that if you post that, you report to the pretrial services no later than 10 a.m. on the business day following the release. I'm going to order that they put you with a breathalyzer to monitor the no alcohol condition that I'm ordering. They've given you the map. They're on the 5th floor of the Dane County Courthouse. And I'll order a no contact director with M.E. You have the right to a preliminary hearing in the next 10 days. Your position on that, Attorney Woodard?
We so request, Your Honor.
Okay, we are adjourned.
Great, so yeah, it's up there. Mr. When you write the initials out, did you say M-P or N-P?
I said M, maybe I just feel his name.
You got it right.
I was in Mary Kids and Paul.
Right. Yes, thank you, Joel.
Then you can.
Thanks for coming up sometimes.
Well, you're out of court, you haven't talked to your attorney, that you have was kind of crowd. Just thought we should maybe begin. You sure you call out and you can put me in the name of the state.
I don't even have exposure.
So, well, if you call the public defender, it's on the sheet, so they can let them know. Okay, you don't need to go with mail. Great, take care.
Next week, Hannah.
Well, generally, you know,
Go on the record in the state of Wisconsin versus Patrick Witz. It's 25 CM 1062 appearances.
Here's my assistant district attorney, Thomas Valeria.
Mr. Witz appeared in person. Counsel Stan Leonard of the Public Defender's Office. During this time, you are not eligible for a public defender. Based upon the evaluation I have in front of me from our office. However, I will represent the court for the purpose of this okay with you. On his behalf, I will advise the court, I have a copy of the complaint, a way reading of this complaint, Your Honor. It appears that the two count matters contained herein are misdemeanor matters from five probable cause by the court be standing. That's for general pleas and not guilty.
Right, and Mr. Witz, do we have a good address on the complaint?
2 Ranch House Lane. Let's see. That's correct. That's good.
That's true.
That is correct, Your Honor.
Okay, and the other thing is, it sounds like you make too much money to get a lawyer through the public defender. They've given you their contact info though. You can always reapply or apply for a county appointed attorney. That's the middle option if you're not able to hire an attorney on your own after today, okay? I'll make findings of probable cause and are not guilty, please. He posted $150 cash bail that's still applying on this case. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant have no contact with Joe W. Joe's first name is spelled J-O, and that the defendant have no contact with M.J.W. Furthermore, I'd be asking that the defendant be banned from the entirety of Ranch House Lane in Madison. I will note that the victim is in support of the no contact.
Right, and Attorney Woodard, any objection?
Contact. They're waiting from my branch of business. If they try to do a training, which I will go before they get it changed. So we can always send companies. You know, very rare when you get your gotta get on the time to request motion with your state to allow it to generate happens you never stay there. Okay. If you're just doing it on your own, I didn't call you. You're being an attorney. I didn't make accusations on you. Real true. When you give an attorney, when an attorney will take off what you're saying and they don't gonna take it for going on. All right. We have one check and a recommendation maker on the state of the
Is there someplace else that Mr. Witz is going to be able to have mail sent to from the court?
right. You know what we do? Because we're talking about 2 ranch house, that is where he did not get.
You think they asked for a ban from the entirety of Ranch House Lane? Right.
And stay somewhere else, you know. They will stay somewhere else.
I'll find some.
Sign somewhere else.
I don't have that.
You know,
I have no place to call.
Okay, and do you have a cell phone?
This breaks my heart. My family, they lie.
Okay. Do you have a cell phone? Okay. I would strongly recommend that you sign up for text message reminders. You're gonna have to sign some paperwork when the ballots will take you over there and you're gonna get released today. But if you sign up for text message reminders, then we know you're not gonna miss future court dates until you sort out where you can get mail. I'm gonna order the signature bond. Everybody agrees that's appropriate. Order a no contact direct with Joe W. and MJW. And order a ban from Ranch House Lane, excuse me. As Attorney Woodard said, that's something that you can have a lawyer file a motion and get in front of the judge. And if the judge agrees to modify that, great. But given the alleged violation of the 72-hour no contact and the victim's wishes, I think it's appropriate that you not have contact for the time based. So, but it's not a 72 hour thing any longer. It's until the judge modifies that. You can't have contact through third parties, any form of communication. So that's not going to get you in trouble here. You weren't using law enforcement. You had this is a tow driver. Don't have anybody contact these particular individuals or go to that residence, otherwise you could be in trouble. The only way you could go back to the residence to get any items is in the presence of law enforcement. But I just wanted to make sure that we're clear because this violation involved a tow driver. You can't have other third parties, friends, family, tow drivers, you name it. It has to be a law enforcement officer. Otherwise, you can't go back to Ranch House Lane. You're going to get arrested, pick up a bail jump, and be in more trouble. Well, you can, but I don't know that you want to because this is all being recorded. You have the absolute right to remain silent. Today's not the trial. I'm not going to be getting to the bottom of all the facts here. I just want to make sure that you understand what you need to know to avoid getting in more trouble after today. Okay.
I have a lot of bottom line. My wife, the daughter, and mine.
Okay. And then maybe that's going to have to be sorted out in the trial. So get yourself a lawyer or apply for a county appointed attorney or reapply with the public defender's office. You get somebody to help you fight these charges, and they can also file a motion to modify the bail. All right. We are adjourned.
Next meets Sir Marian Moore.
Going on here in the state with Hansen versus Sir Marian Moore. That's 25 CM 1057. The appearance.
State Pierce by Assistant District Attorney Bounds Flaring.
Mr. Moore, appears to person with counsel stand where the public defender's office. He's eligible for a public defender. If you have a copy of the complaint, we agree in that complaint. It's a misdemeanor matter. But finding the problem talked about the we stand mute as putting a plea and not guilty.
Right, then we have an address for Mr. Moore on the complaints.
Take a profile of that.
What's the we got 1025 Andrews Drive.
Oh, West Andrew Drive, you know. Cemetery, that is correct. Zip code, that is true.
All right, thank you. I'll make a finding of probable cause. We'll enter not guilty plea on Mr. Moore's behalf. The public safety assessment report recommends a signature bond. What's the state's position on bail?
I have no objection to a signature bond. I would ask that the defendant not use or possess any dangerous weapons.
No objection, Your Honor.
Big order, signature bond conditional be that you not use or possess dangerous weapons as that's defined by the statutes. So that means firearms. It also means anything else that is also designed as a weapon. It's not. But it can mean things like a baseball bat or a steak knife if you're using or intend to use any sort of object in a manner that's likely to cause great bodily harm to death, then you can't possess that either. That'd be a violation of it. All right, we are adjourned. I think we get released at today.
Good, so yes, sir. Next be Shane Warren.
Warren?
State of Wisconsin versus Shane Warren. It's 25 CF 1136.
He's State Pierce by Assistant District Attorney Bounds Flaring.
Mr. Warren appears in person and with counsel stand Woodard of the public defender's office. It appears here that Mr. Warren does have an attorney, Robert Howard. That is correct, right? Your question is this, my question to you is this, if you want me to represent you for the day, because I can, or if you can talk to the court about waiting to have Mr. Howard represent you, or I would be fine with you today, just because I don't want to sit any longer and rather.
Yeah, and you're exactly right. That would be the downside.
I would rather
you would be sitting without bail being addressed at all.
So. Your call, I just have to ask you in that way, and it's I have no problem. Okay. I will acknowledge on his behalf, state the complaint. We agree to that complaint, Your Honor. Looks like there are 4 counts contained therein. There is a felony matter contained in this complaint. The rest are misdemeanors. For finding probable cause regarding misdemeanor matters, we send you. That's for sure. If we do not guilty regarding the felony matter, on finding probable cause by the court, we request a preliminary hearing.
I'll make findings of probable cause and are not guilty pleas to the misdemeanors. Do we know is that Red Arrow trail address that currently is for mail?
Can I have that changed? Just because,
You know the address you want to change to, just state it out loud.
I'm moving out, I'm supposed to be moving out by, the 28th, so.
Okay, then you know what that address is going.
Yes, I do.
All right, go ahead and state that.
2779 Raritan Road, Pittsburgh, Wisconsin. It may already be previously on my file.
I'm sorry, I didn't catch those three names.
Sorry, Raritan Road, that's Raritan.
Thank you. And do you know the zip code?
I believe it's 53713, or I'm not exact. I'm sorry.
I'll look it up. Is there an apartment number?
No, it's a residential in Pittsburgh.
Thank you.
That's my company's location.
Looks like you found that. So I'll make a finding of probable cause and are not guilty, please. There is a PSA report. The recommendation is a signature bond, state's position on behalf.
I have no objection to the signature bond. I would ask, look, one second. I would ask the defendant have no contact with Margarita H. I can have the defendant not use with Sesame alcohol. The director of Margarita first and spelled MARGARITA.
So I just want to say,
Well, before you say anything about the facts of the case, you have the right to remain silent. It's all being recorded.
anything about the facts of the case. I'm just stating that, we are fiancés, and there's a lot more to this case that will be addressed later, but we also do reside at the same location. So that's the only thing. Like I said, a lot of this is a misunderstanding that will be represented later, but I am fine with the no drinking. I don't drink once a week, usually on Friday anyway. So I'm all in compliance. I would just like to finish up that, and I go, if she doesn't want, I can respect that, but at this time, all my stuff and our stuff.
I think he enforced the 72-hour non-pact, and I was gonna have the clerk check to see when that expired, but that was the most recent information I have.
She had requested that just for the time. So we do live together, and we have an apartment that we gotta pack up. So that's the only issue because of that. And like I said, if she wants nothing to do with me at this point, I swear to the court, I'll give her piece. She originally requested the 72 hours. And if she wants more, I'll give her space. Like I said, this whole thing is embarrassing.
Yeah. I understand your position. Anything else from the state or Attorney Warden?
I'll note that I agree the 72-hour never contact is put in place. I looked through the criminal history. I think this is the first time where Margarita H is involved as the victim. She hasn't reached out for our office to indicate she poses the no contact, right? So it's not like we've heard from her saying, hey, I'd like to have contact with Mr. Warren. But I mean, given that, the fact of the matter is Mr. Warren's charged with falsely imprisoning her, and various domestic abuse allegations, which are by their nature rather serious in nature. So, I mean, when I look at that, I think to myself, well, we're clearly looking at an abusive relationship here. I just don't think contact's a good idea right now.
All right. And Attorney Warden, if you wanted to say anything else.
Well, on Mr. Warren's behalf, we're asking for no acts and threats of violence. We can stay there with no acts and threats of violence.
All right. Well, Mr. Warren, I'll be quite frank. I think I got an order to no contact at this point in time. I need to get my stuff in the border. Well, it's not something.
Yes.
So I think I have to order it. The most recent information I have as to the victim's wishes is she doesn't want contact. It's not like she can ask for more than 72 hours. That's what you get if you say you want the no contact. And that's after the arrest. And now we're addressing bail. You're charged with 3 act-free eligible offenses. Those are all cases where the state could be making an argument that there should be cash bail. I don't know how all this is going to play out, but it would be negligent for me to say, yep, go back and have contact with this person until I've heard from them that they've actually changed their mind and they want to have contact. So I'm ordering that. And I don't think this is an outlier decision. And I want you to see in most cases that are similar to this, the no contact gets ordered when the victim has requested it and hasn't shown up to say, you know what, I've changed my mind. Now, you can go back to the residence in the presence of law enforcement. That's the only way that you can do that. Bond can get modified. You can have your lawyer file a motion to modify the bond. If the judge grants that, great. But right now, I think it would be negligent to order anything other than the no contact. So that's what I'm ordering, and the no alcohol. So the no contact with Marguerite H as condition of your signature bond. Any questions or clarifications about how to legally get any property that you need from the residence, sir?
No, I guess.
Yes, you'd have to arrange for a time to go with the police. Even if she reaches out to you, don't respond. You're the one who would get in trouble until the judge modifies this bond. They don't want that, and they'll be right back here, and then their argument's gonna be, well, he's already out on 3 Act 3 eligible charges and he's violating bail and it might be asking for cash. We don't want that to happen, so just make sure you protect yourself having law enforcement assist you.
Yeah,
You got a question?
yes, so I didn't even know what I was charged with.
That's what you've got in your.
Okay.
So that's gonna have all the details and charges.
I never, I was told that, yeah, not any of this, besides the problem, it says I never, we'll get it figured out, I never trapped anyone.
Okay, again, it's probably not advisable to make any statements here because I'm not in a position to essentially have a mini trial here and figure this out. I don't have the victim, law enforcement, other witnesses. So this is what I've ordered. Those are the conditions. They have to be followed. And if your lawyer files a motion, then the judge can take a look at that and modify those. And whether you committed any of this is really going to be a trial issue, okay?
Okay. Okay.
So do you want to prelim in the next 20 days?
Wait,
Okay, that'll give you more time to get your lawyer and chat with them before any preliminary.
And Commissioner, did you order the no alcohol?
Yes, no alcohol and no contact with Marguerite H.
Not
All right.
right.
Very
Thank
good.
you.
You're welcome.
Next is gonna be Marcus Flowers. Flowers? Yes. Stand there and be all honest, please.
Go on the record in the state of Wisconsin versus Marcus Flowers. It's 25 CF 1131 appearance.
The state appears by Assistant District Attorney Thomas Valeria.
Mr. Flowers appears in person and will counsel stand ordered of public defender's office. And advise the court that he's eligible for a public defender. Do have a copy of the complaint in this matter. Upon a reading of this complaint, which we waived, count 1 is felony matter for finding probable cause to be requested in preliminary hearing. Here's count 2 is a misdemeanor matter for finding probable cause to stand mute. That's quick general plea of not guilty.
Right, and do we have the correct address for Mr. Flowers on the complaint?
Yeah, 5228 Campbell Road. Yep.
Yeah, but I have to, I gotta know the days that when I get a jib and then they move something there.
You have another address that would be used?
I mean, I got keys and stuff, you know, but I don't home thing. I went back.
Right now, then, you might be able to say.
Yes, it is, and moving out, moving, I didn't want to do
Okay.
Okay, that's fine. And then just let your lawyer know where you want your mail sent when you get a new address.
Yeah.
I'll make findings of probable cause. We'll get a not guilty plea entered to the misdemeanor. There is a public safety assessment report, recommends a signature bond. There's also Jasmine Meltchure's PSA report that's been uploaded in this case, so I don't know whether Mr. Rogers or the clerk needs to get that into Ms. Meltchure's file. But I thought I would bring everybody's attention to that. And let's hear the state's position on that.
I'm recommending a $500 cap bond in this case. I'm asking that the defendant not use or possess any dangerous weapons, that he have no contact with Ravina. Ravina's first name is spelled Ravina, and that the defendant not use or possess any alcohol. I'll recognize that the PSA recommends a signature bond able to protect that Mr. Flowers' criminal history. I don't see any problems with the parent's history. It does look like there was a cash bond at some point posted in 24 CM 2064. It looks like he was able to successfully post $150. Still, I think the problem here is that it's alleged that Mr. Flowers is allegedly drinking alcohol. He gets into a verbal argument with the alleged victim in this matter. And I think what's startling is that he retrieves a gun, actually possesses it, which forms the basis for the felony possession, and then threatens the alleged victim with that gun. The Glock is located in the house. So when I look at this case, I think that there's a greater level of exposure than someone who's maybe pulled over in their vehicle for just merely possessing a gun. It's more concerning on the exposure end of things when someone's actually using that gun with an instrumentality that could be, I guess, more lethal. I think that's unfortunately what we have here. So I think given that increase of exposure, I think that's some dash is needed.
Okay, and Attorney Woodard.
Council, you recommended how much? I'm sorry. 500. All right, we're gonna request $350, John.
All right. Well, I think there's probably a need for some cash bail. The history appears to be extensive. There's 3 or more prior violent convictions. And I agree with Attorney Valerio's comments that this isn't just driving along in your car and having a firearm that you as a felon are not supposed to have. Allegedly, you're threatening somebody with this. I realize it wasn't discharged. I'm not sure that there's a significant difference between $500 and $350 as far as getting Mr. Flowers to court. Order $350 cash bail. I'll order that you not use or possess any dangerous weapons, because that's defined by the statute. So firearms or other things that are considered weapons, and anything else, if you're using it or intend to use it in a manner that's likely to cause great bodily harm or death, you can't possess those items. 3, I'll order that you not possess or consume alcohol, and then no contact direct with Ravina. B is in boy, is that right? Yes. Okay. You're gonna have the right to a preliminary hearing 20 days.
Wait, Your Honor.
Okay, will be adjourned during this way, sir.
We'll set for a longer, sir.
Next will be Michael Wall.
Waltz.
All the state of Wisconsin versus Michael Walls is 25 CF 1135 and 25 CM 1058 appearances. The state appears by Assistant District Attorney Thomas Valeri.
Attorney Stan ordered with public defender's office on behalf of Mr. Walls to appears in person and is eligible for a public defender. I do have 2 complaints in this matter. One complaint is on May 9th of 2025. It's felony matters contained in this complaint for finding problem caused by the fact that misdemeanor matters contained on this complaint. For finding problem cause, Your Honor, we stand mute as subject of these and not guilty. The second complaint on August 23rd of 2024 is felony matters contained in this complaint, as well as appears that there are all felony matters for finding problem caused by the court. We will be requesting a preliminary hearing.
And are we using the Gary Drive address for mail?
That will give you question for 3202. It is correct, Your Honor.
Okay. Make findings of probable cause in the cases that are not guilty, please. The public safety assessment recommends cash bail. It's the state's position on bail. Sorry, just 1 second here.
I'm recommending $500 cash on each of the two matters that are here for tonight. In the 25 CM 1058 case, I'm recommending a ban from the State Street Alliance Dane area as that's defined in our ban map. A no contact with Corey W. Corey's first name is spelled Cory. That the defendant not use or possess any dangerous weapons. That the defendant not use or possess any alcohol. That the defendant not use or possess any controlled substance or drug paraphernalia without a valid prescription. And then in 25 C Act 1135, on top of the $500 I'm requesting, I'm also asking that the defendant be banned from all Summit Credit Union locations, and that the defendant have contact with John T. All right, so throughout each of these matters, it's alleged that, well, at least in the 25 CM 1058 case, it's alleged that Mr. Walls is on bond of some type of committing these offenses, and I think the court can also just see from CCAP records that just date-wise he was on bond. I will note though that the Summit Credit Union case does appear to the instant date was from August of 2024, so that might actually predate some of the bond conditions that Mr. Walls was on. Nevertheless, when I look at Mr. Walls's criminal history, when we're looking at that misdemeanor case, it looks like he's been previously convicted of slightly similar conduct, right? Because it looks like in March 19th of 2024, Mr. Walls was convicted of a count of misdemeanor battery and 4 counts of disorderly conduct, a count of possessing cocaine, and it looks like he was sentenced to in total 2 years of paper. I don't know if he was revoked for that. Do you see a DOC pulled on this one?
I'm not seeing one.
All right. So I don't know. Still is concerned that if many of these offenses allegedly while around the time he's on paper, might not have a big sign. Still, it looks like the 25 CM case is actively eligible because of the misdemeanor batteries act very eligible. So I think there's some data you'd like for these cases. Attorney Leonard.
Good morning, Judge. Thank you. Well, Your Honor, Mr. Walsh. All right. Mr. Walls, I really trained the age. Mr. Walls, he's a poor man and does not have wherewithal or cash bail. One of the cases in the 2024, as you quite well aware of, the uttering of forgery, and then these other matters are really violations of bail jumping for the most part. Is disorderly conduct and a possession, which is a 30-day matter. So we're asking for a chance again, Your Honor, for a signature bond on both cases.
Right. Any response from the state?
Well, I think we'll need to do a deeper dive on Mr. Wells' criminal history because lots of these instances where he's in downtown area and whether he's under the influence of drugs or alcohol or a combination of both, he hurts people, attacks people, right? And I think that's consistent with behavior that we see exhibited in the 25 CM case. So I think that heightens the amount of exposure we're still up with the misdemeanor case in that matter, and then the property case in the 25 CM case. So, I mean, given all that, I do think that there is some for at least some cash credit. I think that, I think for the stated that that should be worth it.
It does, because he's at the very top of the scale for the criminal activity. I guess what's concerning on this record is it looks like he's been convicted of a lot of violent crimes. Previously, the clerk looked up the was terminated from supervision, I think back in October of 2024. So it didn't work for very long. The history suggests that he picks up a bunch of cases, doesn't comply with the general bond condition, at least, and not pick up new crimes. And here, in one of these cases, is a misdemeanor battery. He's out on bail and a disorderly conduct while armed. All like 3 eligible offenses. It looks like he's actually gotten more than $500 cash on a number of other cases in the last couple of years. Arguably, the state's request is light. I'm not going to go above it, but I'm not going to go below it either. So I'll set $500 in each case. I think in the felony case, there was a ban from Summit Credit Union, no contact director and director John T. I think that's appropriate. In the misdemeanor, we'll order a ban from the State Street Landing area. It sounded like it has been an issue for Mr. Walls. So maybe you've seen the map before. We'll give it to you again. Take a look at that because they know everybody who's not supposed to be there. You'll get pinched in no time. They can go back. Now also order no contact director is Corey W. That's not use or possess dangerous weapons. Possess defined by the statutes that you use or possess any alcohol or controlled substances or drug paraphernalia unless you have a valid prescription. You would have the right to a preliminary hearing in a felony case in the next 20 days.
So request your own.
Okay, we'll get that sent and we are adjourned. Great, let's start in a second. And soon the next one might be the last one because I didn't see anybody from Milwaukee security detentions. A lot of them cleared up.
I think that other name was added to the wrong day. I think it's for tomorrow.
Understand about nuances.
On the record in the state of Wisconsin, Javar Clark is 25 CM 1054 appearances.
Savior by Assistant District Attorney Thomas Blair.
Fine, prison person with counsel stand ordered of the defender's office. I can advise Mr. Clark that at this time, he needs to contact our office, the defender's office, if they wish to have an attorney. Okay. At this point, I will represent you. It's only going to be for the day of service today. Got information to call our office and you can determine your eligibility. But I like you to get the attorney and help me. There's attention there. All right. Clark is 17 years old, by the way. We have a copy of the complaint. We read that complaint. Regardless of civil matters therein, the misdemeanor matters when the party don't result by the court of the statute. That's correct and fees and that field. Okay, and Mr. Clark, do you remember the address on your copy of the complaint for mail notices from the court? Yeah. All right. And they'll give you the public defender information. So if you can't hire an attorney on your own, give them a call and see if you're eligible for an attorney. If you're kind of caught in the middle, you can apply for a county employee. I'll make a finding of probable cause and not guilty, please. The public safety assessment report recommends a signature bond. What's the state's position?
I have no objection to the signature bond. I would ask that the defendant kind of contact with Dane, yes, and that the defendant get down from the 3200 block of Dane Road. That's TOPPING.
And I'm sorry to say Faith. S.
Yes.
Any objections?
No objections to the recommendation made by the state, Your Honor.
We'll order a signature bond. Conditional being no contact director and direct with Faith. Pass in a ban from the 3200 block of Topping Road in the village of Shorewood Hills. We're going to get released today and we'll be adjourned.
How's everyone?
Okay.